Hello, I'm Kent Myers.
I'm Mick Cornett, and it's time for the verdict. As a part of its traditional and continuing commitment to public and community service, Crowe and Dunleavy Law Firm presents The Verdict, an objective discussion of contemporary legal issues hosted by Kent Myers, and also brought to you by a friend of Oklahoma Lawyers for Children and Delta Dental Plan of Oklahoma. And welcome to The Verdict. I'm Mick Cornett. Well, this week's show will be the first of 2 episodes concerning law and the workplace. And let me introduce one of Oklahoma's top legal experts and my co-host, Kent Myers. Kent, what do you mean by law and the workplace?
Well, we have a lot of controversy all the time about discrimination and what employers and employees themselves can do in the workplace and outside of the workplace. We're going to be talking about what is an appropriate standard to use to hire people or to reject them for being hired. Can we discriminate based on color? Can we discriminate based on national origin? Can we discriminate based on religion, on sexual orientation? We're going to be talking about this show and the show that follows in a week or so. We're going to be talking about sexual harassment. We'll talk about what kind of rules are permissible, and we'll talk about how those rules are enforced, and we'll be talking with 2 of the enforcers of those rules.
And I would assume we'd be talking about not only hiring and firing, but demotion and promotion inside of a firm.
Absolutely, all of the aspects of it. It is a constant controversy in the marketplace, in the workplace. Employers aren't sure what to do or how to do it. Employees aren't sure whether they've been wronged or their rights have been violated. This is an area, to throw out kind of a silly pun, where there are lots of wrongs and there are lots of rights. And we're going to try to get it straightened out.
Well, it should be an interesting topic. Law in the workplace. What defines discrimination? What's politically incorrect? What's illegal? It should be a lively discussion, and it'll take place right here on The Verdict.
I enrich our cultural landscape.
I help define our quality of life.
I am one of 4,000 artists in central Oklahoma who receive
support from Allied Arts, this community's united arts organization.
I am an Allied artist.
It's got to be around here somewhere.
Don't worry, we'll find it. Just calm down.
I swear it was right here on the desk.
All right, if I were a Will, where would I be?
It's the only copy. Without it, we're out $3 million.
I know.
Hey, accidents happen. If a condom breaks
Or you have unprotected sex.
You have 72 hours to reduce
Your risk of getting pregnant.
It's called emergency contraception.
Got questions?
Call Planned Parenthood.
All children deserve a life of hope and love. But sometimes they experience a life of pain, neglect, and abuse.
When that happens, each child deserves all of the quality assistance and representation that can be offered in our legal system. Oklahoma Lawyers for Children has over 350 of the best attorneys and volunteers in Oklahoma County who donate their time and services to represent children. For more information, call 405-23-CHILD.
Oklahoma Lawyers for Children, helping to bring hope and love back to the lives of abused children.
And welcome back to The Verdict. Mick Cornett with Kent Myers, and we're ready to discuss the issue of law in the workplace. Kent, why don't you introduce our guests?
Well, we have guests this week that are oftentimes, or at least will be, on opposite sides of the table from each other. Let me introduce to my left Holly Waldron. Holly is a lawyer, a trial lawyer with the EEOC, the Equal Employment Opportunity Commission. She has been a trial attorney with the EEOC since 1999. Prior to that, she was actively involved in private practice representing workers. On the other side of the table, I have Leonard Court, a partner of mine, I'm pleased to say, and a person with a perfect lawyer name, Court. Leonard is an OSU graduate and a Harvard Law graduate. He is a lawyer that represents employers all the time. He has a couple of accolades I'd like to mention. One is that he has been president of the Oklahoma State University Alumni Organization, the national president, and he was designated recently as a distinguished graduate from Oklahoma State University, and he is known generally in the community as the Dean of Labor and Employment Lawyers in Oklahoma. One thing I failed to mention about Holly, that I want to just jump back and do it. Holly graduated from the University of Oklahoma, so we have Oklahoma versus Oklahoma State today. She's wearing red, he's not wearing orange, but that's all right. We'll let that go by. Holly graduated both undergraduate and law school from the University of Oklahoma. So we have people from different universities who represent different sides of the table in these workplace-type discrimination matters. Let me start with Holly. Holly, you work for the EEOC. Please tell our viewers what the mission of the EEOC is and how does it work?
Well, Kent, the EEOC stands for the Equal Employment Opportunity Commission, and the commission is a federal agency that was organized in 1964. This year, the EEOC celebrates its 35th anniversary. The EEOC's mission is designed to eradicate employment discrimination, to eliminate it. Mostly what we deal with are employees, but we also deal with people who are applicants who feel like they haven't been hired unfairly. And it's the job of the EEOC to initially take those complaints of discrimination and conduct an investigation to see what's been going on in the workplace and see if there has been discrimination, to see if we can eliminate that. And if there has been discrimination found, then sometimes the EEOC will file a lawsuit against that employer on behalf of the United States government, and that's where I come in. That's my job as a trial attorney, is to prosecute those claims for the EEOC.
So in the cases you file, your client is the United States government, but the witness or the party or the grieved party is either the employee or the applicant.
That's correct, and then the employee has the opportunity also. They can join in the lawsuit and represent their interests as well.
Okay. Leonard, how do you advise employers to avoid workplace discrimination problems? What do you do?
Well, we try to spend a lot of time training and working with employers, particularly their supervisory workforce, to try to give them an understanding of what the law is. Many employers have a general or vague understanding but don't understand some of the specifics. Certainly frontline supervisors often have not received specific training. So that's where we try to start, is with the educational process.
Well, let's look at generally the foundation of workplace discrimination. By no means the only precedent for it, but the Title VII of the Civil Rights Act of 1964, I've excerpted here in a graphic. So let's take a look at it. It says, "It shall be an unlawful employment practice to discriminate against any individual because of race, color, religion, sex, or national origin." We're going to be talking about that in these next two shows, but we'll be talking about other things as well. I'd like to start first, Holly, to ask you about testing applicants or employees. I'm confident it's probably permissible to test one on their intellect, on their aptitude, but what about drug tests? Are those permissible, and if so, under what circumstances?
Well, drug testing is certainly permissible. That's something that isn't governed by the EEOC, but is typically governed by state law. The state of Oklahoma would set forth rules and regulations as to how an employee could be tested and under what circumstances. Where the EEOC would be getting involved in drug testing would be if the employer is singling out certain groups of employees for testing. For instance, they only want to drug test Hispanic Americans and they're not drug testing the other employees. that would not be permissible.
What if they're only drug testing hourly employees as opposed to management or salaried employees? Would that be a problem?
I think you would have to look and see who makes up your group of hourly employees and who makes up management. If they are really doing that for a reason and they're not doing it simply to eliminate or segregate one group of people out from the other group, then it would be okay. But there again, if they're doing it under the pretenses of trying to discriminate against one group of employees, then that would not be okay.
What about polygraph testing, Leonard? Do you see that happening in the workplace?
No, Kent. Frankly, there is a specific federal statute that in most respects prohibits polygraph testing. There are some few limited exceptions dealing with law enforcement, national security, but other than that, polygraph testing has pretty much disappeared from the workplace.
Okay. Let's change the subject, if we may, to something that somebody my age might be more sensitive about, and that's age discrimination. What are the general rules, Holly, about age discrimination in the marketplace?
Well, there are not Title VII, but the Age Discrimination and Employment Act, which came after Title VII, prohibits discrimination against individuals who are age 40 years minimum on up. There used to be a requirement that once you reached a certain age, you were no longer protected, but now as long as you're 40 or above, you're protected from age discrimination. So the employer cannot simply go through and say, I'm going to now fire all of my age 55 and older workers, just because I don't think old people make good workers anymore. So
they quit working and start doing TV shows.
or playing golf.
Let me ask you a question. This is kind of a specific example. What if there are physical limitations that caused by age and the employee can no longer do the work or handle the workload that they handled at a younger age? How was that handled?
And that's a different scenario. You have to look at the factual situation of what's going on. If the employee truly cannot perform the functions of their job for which they were hired to do, then it's okay for the employer to make some adjustments there and to figure out what's going on. But just to come in and make a blanket statement that, once you reach a certain age, you're no longer valuable in the workplace, or we don't want you because you're either a liability or you're going to cost us too much money down the road, that's not permissible.
Let's stop it right here and take a break. Hold that thought. We're going to interrupt. We'll be right back. You're watching The Verdict. Mick Cornett, Kent Myers, and our special guests. We're discussing law in the workplace. What's your verdict?
Yeah, campfire's a lot of fun. You get to make some friends. You get to do some cool stuff. Campfire's for boys too, not just girls. But hey, campfire's definitely for kids. So call the campfire office nearest you to join in on the fun. 'Cause let's face it, you're not getting any younger.
St. Gregory's University has been changing the lives of people like me for 125 years. Affordable, private Catholic education, balanced with dedication to community and service, makes St. Gregory special. We're extremely proud of our students' outstanding academic achievements and our nationally ranked athletic teams. It's when you help a student build a future of balance, integrity, and service that you change a life forever. St. Gregory's, a community for life.
I pledge allegiance to the flag of the
United States of America and to the republic for which it stands,
one nation under God, indivisible, with
liberty and justice for all.
Every day Americans make this pledge, but few think about its significance. It's our job to make justice a reality by providing legal representation for all citizens. Legal services, keeping the promise of America.
Every day, in state governments throughout the country, crucial decisions are being made that affect the lives of children and their families. But as this process takes place, children are often left voiceless. When these children raise their hands to be heard, is anyone listening? There are people listening. They are child advocates. Join us and raise your hand for kids.
We're discussing law in the workplace. Welcome back to The Verdict. Mick Cornett with Kent Myers. Where are we here?
I wanted to go back to Leonard just for a minute to ask him to comment on, in the age discrimination area, mandatory retirement and any example he's got about age limitations.
At this point, mandatory retirement on a specific age, with the minor exception of what's called the highly salaried executive, is considered illegal. The statute, as Holly indicated earlier, has from time to time had upper age limits, first 65, then 70, then Ronald Reagan, who was no spring chicken himself, got that removed. And so we have had mandatory retirement over time, but now that's been pretty much eliminated with a variety of limited exceptions. And additionally, if I could comment on something we were talking about right before the break, there is a limited, Mick, area in response to your question called the bona fide occupational qualification, where if you can prove that age is a specific limitation, you may be able to set a mandatory limit on who can do the job. One example of that is, for instance, commercial airline pilots have a upper age limitation, and after they reach that, they're out of the cockpit, and that has been held to be legal, in part to the response that you're talking about, the slowing of a variety of functions because of age.
Leonard, we know that, and I think you know probably better than some, that we now have women doing jobs that perhaps sex discrimination kept them from performing before, such as women umpires, women sports reporters going into the locker rooms after the game. How has that come about?
Well, that has been a specific result of Title VII and the prohibition against gender discrimination. The advent of the female into sports broadcasting, sports reporting, and sports officiating has been a direct result, I think, of Title VII, and I have kind of a personal touch with that because my wife, for some years, was one of 2 women wrestling referees here in the state of Oklahoma, and so she's had some firsthand experience at the kind of comments and discrimination that
Amateur wrestling?
Yes, absolutely. High school wrestling.
Yeah. Well, Holly, let me ask you about sex discrimination in relation to pay. Is it permissible to pay a female employee, for instance, doing the same job as a male? Is it permissible to pay them less?
It's not, but Kent, you have to look at the job. You have to look at, are they performing the same jobs? Do they have the same seniority? Do they have the same educational level? All of those factors. And if you have 2 employees that truly are equal, they're truly performing the same job function, then you do have to pay them the same amount of money. Leonard and I were discussing earlier that we've not seen so many of those Equal Pay Act cases that we used to see in the past, but we've got one pending right now on file there in Muskogee in the Eastern District. And it was surprising to me to see that because I assumed that the public was more educated and aware that that was illegal, but we are still seeing some pay disparity cases.
Well, how has the maternity rights of workers changed recently or in the past few years? When a woman has a baby and she is entitled to time off, how does that work, and how does that work insofar as the father is concerned?
Well, under Title VII, both the father and the mother are entitled to take some leave if leave for other disabilities in the workplace is offered. The employer doesn't necessarily have to pay its employee while they're on maternity leave, but for instance, if they pay an employee who's been injured on the job and is taking paid leave, they then have to offer that same type of paid leave to the mom while she's on maternity leave. Again, they can't take adverse action against a man because he wants to take a couple of weeks off to be with his newborn. So it has to be offered across the board for men and women.
But it doesn't have to be with pay?
It does not have to be with pay.
But I presume if you're paying some, you have to pay others as well.
That's correct. You can't single someone out simply because they're pregnant or on maternity leave.
Okay. Let me change the subject. We've seen a lot, at least in the press, about sexual orientation and whether a worker is gay or not. Is that subject to Title VII, Leonard?
No, Kent, it actually is not. The federal statute does not cover sexual orientation. The publicity we're seeing is either generated by a variety of state statutes that do cover sexual orientation or attempts to amend Title VII to include it as a new protected category.
Well, I saw the word sex in the Title VII that we looked at, but that is not been construed to cover sexual orientation.
The courts have not yet construed that to cover sexual orientation.
Let's look at a graphic of the 10 states plus the District of Columbia that have enacted laws to protect employees against sexual orientation discrimination. Colorado covering state employees only. I won't read the list. It's readily apparent there, and Oklahoma is not on that list. Do either of you have any view about whether we're likely to see Oklahoma on this list anytime soon?
I would be surprised.
I would be very surprised.
Let's change the subject, maybe. Let's talk about racial discrimination. How prevalent is racial discrimination in the marketplace, Holly, in Oklahoma?
Well, we actually see a lot of complaints of racial discrimination. You know, obviously some of those have merit, some of them don't. We see a lot more racial harassment claims than you know, I think we would like to see. It is still prevalent. There are still instances of racial discrimination that are less obvious, say, than the racial harassment claim. But we still see cases where they're, you know, got the hangman's noose in the workplace, or they've got whites only written on the water fountain. That happened just recently in a case that we tried this last spring. So it's still out there, unfortunately. But then there's a lot of subtle discrimination that's harder to pick up on. But,
well, Leonard, comment, would you please, on what is the employer's liability or responsibility if employees themselves are harassing racially other employees?
Well, and it's not just racially, Ken. It would be in any of these protected categories. The responsibility ultimately lies with the employer, whether it be a supervisor, coworker, customer, or vendor. If the employer becomes aware of it, knows or should have known, and does not take prompt remedial action, then the employer has liability depending upon what the adverse job action is that could run from, in a termination case, back pay, potential front pay, what's known as compensatory damages for pain and suffering, and punitive damages up to a capped amount, which at its most would usually run $300,000 for the cap on compensatory and punitive damages.
Well,
got about 30 seconds left with our guests.
One quick question. Okay. Private clubs. Holly, can private clubs, golf clubs, country clubs, can they discriminate in their membership?
well, private clubs are not covered under Title VII. They are specifically exempted out. So unless there is some other law that covers them, Title VII does not cover them, and so I suppose the answer is yes. They can make choices based on race, age, that sort of thing, without bringing Title VII into play.
We'll have to wrap it up right there, Mr. Waldron, Ms. Court, or Ms. Waldron, Mr. Court. Thank you very much for coming by. Did I discriminate there?
Not intentionally.
We'll have a few final thoughts when we return. You're watching The Verdict with Mick Cornett and Kent Myers.
Hello, my name is Ted Smith. I'm president of the board of directors of the Oklahoma Disability Law Center. ODLC provides free legal services in civil matters to people with physical and mental disabilities.
I'm Mike Sykes, vice president of ODLC. For more information, call 1-800-880-7755.
The Oklahoma Disability Law Center provides high-quality legal services to people with physical and mental disabilities.
In Oklahoma, there are more than 1,600 children waiting to be adopted. They're of all ages, and for many, home has been a source of pain and conflict. They've dreamed of finding a better life and a loving family. Consider adoption. For more information, call 1-877-OK-SWIFT or visit the website www.okdhs.org. Adopt. It may be the toughest job you'll ever love.
Boy Scouts of America, where above all else, character counts.
Bringing out the best in each student. That is the simple goal and tradition of Heritage Hall.
The focus on the individual shapes the educational experience at Heritage Hall. Each student benefits from small classes, able, dedicated teachers, a solid academic curriculum, and exceptional co-curricular programs of athletics, arts, community service, and other activities, parental involvement, personalized counseling, and the development of responsibility, integrity, and love of learning. If you want education taught with pride, then you want Heritage Hall.
Welcome back to The Verdict. We're wrapping up the first of 2 episodes we're going to have on law in the workplace. Kent, this was a good show.
It was a good show. We didn't get to cover all the things we want to, but we'll pick that up on another show. When the water fountain example was mentioned just a few minutes ago, it made me think back when I was 5 years old going down to the Santa Fe station in Oklahoma City to meet my father, who was coming back from World War II at the time. And I remember going up to a water fountain and seeing a sign actually in Oklahoma City that said whites only. And I just, as a 5-year-old, could not imagine what they were talking about. I rode to school every day, not on a school bus, but on a city bus. And the sign, when you got on, was blacks, or whatever the phrase was, colored was a phrase, I guess, at the time, moved to the back of the bus. And I, for the life of me as a youngster, could not understand what was going on, and I'm glad to see that none of that, or at least doesn't happen near as much anymore. But we have lived with discrimination. We still live with discrimination, and as we said at the outset, there are many rights out there, and there are many wrongs, and thank goodness we have people like Holly Waldron and Leonard representing various parties to this thing to get these things sorted out so that perhaps our culture can be closer to discrimination-free.
Let's discuss our website that people can log on to.
Yeah, let's look at the graphic for our website. Our address is www.theverdict.tv, not .com or .org or .edu or anything else, but .tv. I hope you will tune in to the website, look at it, find out a little bit about what we're doing and the shows we have done, the shows we intend to do. Some of the links we have there are interesting to check out. We have worked to make that website interactive for the viewer, and we hope that you'll respond, for instance, to this week's show. Let us hear from you on whether we have too little regulation of discrimination or we have too much regulation. Are we just worrying about what's politically incorrect or politically not appropriate, or are we worrying about what's against the law? And are we straightening up correctly or not?
And we'll be back next week with another episode of The Verdict. This program was brought to you by Crowe & Dunlevy, a professional corporation. And also brought to you by a friend of Oklahoma Lawyers for Children and Delta Dental Plan of Oklahoma.